Welcome to our first episode on this our podcast where we are probably going to share most of the things that as SME owners, how and what we face. And we are very happy to have our very first guest speaker, Evan Lee. Do a clap. All right. So Evan Lee is I will call Evan. Evan is he's running his own law firm. All right. He specializes in medical negligence. I think, Evan, when I first approached the public on LinkedIn, and then you dropped me an email, which of course I'm grateful for. So I believe that you want to share about your experiences in running your own firm, your experiences in juggling everything on your own, and how does it feel like? Okay. Over to you, Evan.
Right, thanks, Jason. I didn't know what to expect when I reached out to you. I just thought it was a very interesting initiative that somebody is willing, a young lawyer is willing to put other young business owners and law firm proprietors on the stage to share what's been going on. And I myself, being what people call a friend of mine calls it a solopreneur, meaning that some of us don't have employees, me included. I don't have any employees. I'm lawyer, secretary, sometimes dispatch. And the reason for that is because not every one of us has the privilege of being able to have financial backing.
Understand.
So I've been running my practice for 3 years. I've been a pruner, I guess, for 3 years. That's why the title Solo on Call.
Yeah.
And as you pointed out, my primary area of focus is medico-legal claims. But I do other areas of civil litigation as well.
Right. Now, Evan, before we proceed straight to the experience, maybe backtrack a little bit about yourself, a bit of history of yourself. But before you set up your own practice, what was your experience as an associate up all the way to the senior associate role and things like that? Maybe just share a little bit of your experiences on that.
Okay. So when I entered my pupillage, I didn't actually know what I wanted to do.
Right. Typical.
Yeah, I didn't know I didn't know the difference between corporate and litigation.
Right.
The only sort of knowledge that was imparted on me was regrettably from suits, which I think gives us a false impression
Right.
of what practice really is.
Right.
And there was no demarcation between the two practice areas, but all I saw from suits was fancy suits and the prestige and the money that comes with it.
Yeah.
So I did my pupillage in a full service law firm, Mark Kamara Philip Cole. So I was exposed to both corporate work and also litigation. And after my pupillage, I found out for myself that I veered towards litigation.
Yeah.
So then I joined a general practice law firm after my pupillage. In 2017, I joined another medical legal law firm is rather well known for acting for patients.
Right.
Yeah. So that's where I developed my interest in this area of law,
Right.
particularly medical malpractice claims.
Right. But what sparks you to have the interest in, because medical negligence or medical legal field is a very niche area. And I suppose we don't study that in our modules. Most of the time, most of us, of course, there are unis that provide elective modules on that. But what gives you that thought like, oh, you know what? I want to do medical negligence. I want to act for the patients, things like that.
Okay. Two things. One is generally I like helping people and I like the idea of representing somebody's interest. And in the field in medical negligence especially, where it's usually between a patient and the healthcare providers, it's always akin to somewhat of a David Goliath fight. Of course, not every patient is super rich, but most hospitals and government and private, they have comparatively better access to resources. So, and I feel a
There's
sense of
unequal bargaining power,
yeah.
right?
So I feel a sense of satisfaction when I help people.
Right.
You know, I like to be able to help the little guy, and of course in meritorious cases lah. I'm not the type that files frivolous cases. I like to help the little guys attain to put their lives back together as best as they can.
Right.
And also it helps that a lot of my family members on my mother's side are
Right.
in the healthcare line. So you know, it sparked my interest like, wow, what drew them to healthcare? You know, and that's where I thought to myself, you know what? Maybe I like to at least see what's in their world.
Right.
But I wasn't smart enough to qualify for medicine, so what did I do? The next best Asian stereotype lah, law lah.
Yeah. Okay. So after you did your pupillage in Markham Maria, then you proceeded with your associate role. Is it in the same firm or right?
I went to the firm Wong Kian Kiong.
Okay.
But now it's no longer
In existence.
no longer in existence.
Right.
Then I went to P.S. Ranjan and Co. That was that firm where I first gained exposure to medical law, and that's where my interest was peaked. After P.S. Ranjan, I thought to myself, you know what, I can't be a one-trick pony.
Right.
I need to make sure that I know other areas of law, because there were people coming to me and asking me about other areas and I couldn't help them.
Yeah.
I had no idea what to do. So I went into another firm, a general litigation firm, two other general lit firms before I realized, you know what, I think I like medical law.
Right.
Yeah, so I've had experience in, I've dipped my hands in other areas, and I found myself still veering towards medical law after all that years.
Right. So that took you how long? From being let's not count the pupillage duration. Let's just talk about the associate up until where you start your own firm. So that duration is roughly.
I started in 2023, so 2023 minus 2017. See, this is why I'm in law. Cannot count. 4 years.
Right.
Yeah, 4 years.
Right. Okay. So in that 4 years, I suppose you have, in a way, found your passion.
Yes.
Right? You have developed your interest, your passion in the medical field, and as what you have said, that your mom is in the healthcare sector.
My mom's family.
Your mom's family,
side, yeah.
Right? In the mom side, lah. Right? And then you, that's why you want to help people. That is in a way unequal bargaining power, because there are things where, we have a big companies. Right, we have hospitals, we have insurance companies and things like that, right? And then of course we have patients, or we have victims, or like or people who have been injured, things like that, and you're there to help, right? Now, with that passion, I suppose that you want to start your own firm, or is it because of any other reasons why what sparks you the thoughts of running your own firm?
I've always wanted to set up something for myself.
Right.
Yeah. To build something for myself. Of course, along the way, when you work for people, you may think, hey, you know what? Maybe I can stay with them. Maybe I can stay. I can build something with them. But that's not always the case, lah.
Right.
And especially with the pandemic and everything changed. So when I went before I set up my firm, I was in the general litigation practice.
Right.
I found that I didn't really like general litigation. I don't mind doing it, but it wasn't my true passion. And at that time, there were no other firms, because we are a very small circle, actually. If you work in a firm that does predominantly patient work,
Right.
it'll be very difficult for you to transition into a defense outfit.
Right.
And vice versa, because
Right.
of conflict of interest.
Correct.
And at that time, I was already in my 6th year of practice. So once you hit your 6 years, I don't know who set the standard lah. If you hit your 6 years, it's either you're on your way to partnership, or you're on your way out of the legal profession, if that is not on the table.
Yeah.
So I tried applying to others, but I think nobody could afford. Not to say nobody could afford lah, but I couldn't get the salary that I wanted, because
Correct.
I think to be fair, when you're in your 6th year, you are quite expensive already lah.
Yeah.
Yeah. So a lot of firms may not be so willing to spend the money, especially if fresh out of a pandemic.
Yeah.
Yeah, everybody is really being careful with their expenses. So yeah, that's
Right.
where I said, you know what, let's just set up my own lah. And
Right.
I also figured for myself, because I took it upon myself to learn the nitty gritty. So as the former AG Tommy Thomas said in his book, there is dignity in labor, and I took that to heart. So
Yeah.
I learned the ropes of filing, I learned the ropes of bundling,
Yeah.
photocopying, and dispatch work myself. Most of the drafting, when I was an associate, I did it all myself. I rarely relied on my secretaries. Of course, that one secretary I had was great lah, but
Yeah.
I took it upon myself to learn as much as possible, because you'll never know when one day you have to stand on your own feet.
Correct.
And right now I'm doing exactly that. I'm doing everything from bundling, from even walking to the post office, going to the courier office. I'm doing all that myself. So yeah.
Right. So with that in mind, that you are doing everything from scratch, I was supposed A to Z, because on like what the title suggests, Evan solo on call, right? So with that experience, how do you feel, or rather, if I put it this way, what motivates you to keep going? You see, because I personally, I know how it feels like. You know how it felt when I started out not in this firm. When I started out as a paralegal, where I was in a very small firm. Then above me is just the partner himself, right? So you have to do your bundling, your binding. Even I had to serve documents over the weekend. Sometimes when people avoid service and things like that, right? So it's not an easy thing, because generally you have to make sure that everything is in order. If there is a slight chance of mistake, of course back then I had my partner to dodge a bullet lah, right? But right now you are on your own. Okay, so what is a thing that keeps you going? I think you're running this firm for almost 3 years, where you have to do everything yourself. Your journey, maybe you can just share to the audience. How is it like for you personally?
Okay. What keeps me going is I have a family.
Right.
I have to raise a child. Yeah. And second, also because when you're married, you have a matrimonial home to maintain.
Right.
And I guess I took it upon myself to get a matrimonial home first, which means I'm saddled with a mortgage.
Right.
So that you cannot run away. You have to pay it. So these are the things that motivates me to keep going. The financial consideration, one, and I think it motivates everybody in our generation right now, especially as we hit our late 20s, now 30s. We start to think, you know what? Maybe I can start settling down. Even if you're not married, you would have thought of getting a home for yourself,
Right.
for the future. Who knows? Maybe you might decide, you know what? Let's get married and start a family. You want that option for you. So that is what keeps me going. And
So the first thing is a commitment, the
commitment.
personal commitment. All right. And then the second thing?
The second thing, of course, is my initial dream, to build something for myself. Because if this firm stays stagnant, then what use is having a firm, or you're building your own thing, if it's going to stay stagnant? And of course, it goes back to the financial consideration. If you stay stagnant, you will not be able to keep up with inflation. And every year the cost of living rises and is constantly rising, and people are moving forward. So if you don't move forward, you might get swallowed up. And it's a real fear for small firm owners.
Yeah.
Maybe just me, I don't know about other small firm owners, but there is a real fear of being swallowed up
Correct.
by
Correct.
your competitors, or just by the economy.
Right. Right. So, I mean, if we were to compare, I'm not so sure about the medical field. How is it like in practice? Of course, in terms of the construction field, what we lawyers generally experience, especially for the small firm owners, I think we we have no, I can't say we have no say, but rather we have a very limited access to act for the big companies. So, for example, let's say I suppose I'm just assuming, correct me if I'm wrong, that most of the time hospitals, insurance companies, they usually are on panel with these big firms and things like that. I think vice versa as well for construction field as well. Most of the time you have developer, right? The big shots, they have the retainer engagement with the big law firms. As for us, the SMEs, even for me myself, it's not easy to penetrate into the market, right? Because what we normally have access to the market is that, look, these are the SME companies that you can help, as compared to you queuing up with the big shots or with big firms to act for the listed companies or with the big the big construction companies per se. So I suppose that also applies to the medical field. Is that true?
It's quite similar actually. Yeah. Traditionally,
Yeah.
what a lot of people do is they get on the defense panels first. They work for big firms. They lobby on their contacts in the insurance companies. This is just for private hospital, because government hospital is under the AG chambers, so
Right.
they are not part of this equation. So a lot of the insurance companies, that back then in the 80s, in the 70s, how many people did this area of law?
Yeah.
There were not many people to talk to about this.
Yeah.
So these guys leveraged on their contacts, and when it was time to set up on their own, they just brought them with them. Yeah, and they will stay with them for a while until things change. And things do change. Panels do off and on look for new lawyers, look for new younger lawyers. For the medical field, so far it has been quite stagnant. It's been the same faces since 2017, and even before that, it's been the same faces, the same. And one thing in common with a lot of these panel solicitors is that they usually come from big firms and older established firms. Of course, business-wise, it makes sense, go for somebody who's more senior, go
Yeah.
for somebody who's more established.
Right.
But the reality of it is, which nobody will tell you, of course, is what exactly do these guys pay?
Right.
How much do they pay?
Yes.
You get very different stories.
Yeah.
Some say, okay, it's fine. I can sustain the firm on this, and
Yeah.
just by looking at how long they've survived,
Yeah.
it's true they've sustained.
Yeah.
It's sustainable, but can they grow?
Yeah.
We don't know.
Because I think the issues of undercutting is in existence.
Yes.
Right. I think because this podcast is going to be very transparent, it's going to be a very genuine podcast, and I think we should share, is that me myself personally, I've experienced where there are lawyers who undercut each other here and there, just so that they can get the file, as in the construction industry areas lah. Okay, but in the medical field, I suppose it's the same thing as well, right?
I'm quite happy to say that so far in the medical negligence field, we have been quite steady lah.
Right.
We have not yet succumbed to what has been widely practiced in the general personal injury line.
Right.
Most notoriously the road motor vehicle accident line. It's not exactly a secret. The Bar Council knows about it. Even leads know about it. I've had people approach me. They don't introduce themselves.
Right.
They don't tell me what their case is about. The first question they open up either on email or on a telephone call is, do you do no win, no fee? I'm just like, how do you even know that term? Yeah.
This is from a public.
Yes.
Right.
From random people who call me up from different states in the country. Do you do no win, no fee? Do you do contingency? Can you pay for me first and then I pay you back later?
Wow.
And I think to myself,
Wow.
wait, how do these people not even know what that term is? I thought only lawyers know what it is.
Yeah.
And straight up, I'll tell you all, it's actually illegal. No win, no fee is illegal. Until a time when it becomes legal, it is illegal. I know in the UK, in the UK, in Australia, in
Yeah.
the US, it's legal
Correct.
but it's only for limited cases.
Correct.
And you have to qualify for it. You can't just have a blank. There's no blanket application. But in Malaysia, for the time being, it's still illegal. But of course, does it stop people from doing
Yeah.
this? No, it doesn't.
Right.
So it's an open secret that in the personal injury line, a lot of lawyers operate on the no win, no fee, which means they don't take any upfront payment. They finance the litigation, including some of them going as far as paying the accident victim a living wage or a
Wow.
monthly living wage, and then recouping it back as disbursements later. I have my I have my views on it lah. One, it's illegal. Fine, it's illegal. Illegal means illegal, So you're not allowed to do this. But when I look at why they do this, I see that there is a reason why a lot of people, a lot of leads,
Right.
the regular Joe, would ask for this kind of arrangements. It's because they can't afford the lawyer's fees.
Yeah.
Which I am told that is quite different from your field,
Right.
because you are dealing with mega, multi-million dollar projects.
Yeah.
These guys have money to spend. Well, one thing I've also heard about your field is that you do not tolerate this kind of no win, no fee
Correct.
things.
Correct.
And
I mean, there are still people doing it. There are definitely people doing it. I've also seen it. I've also heard it. Same thing, contingency, or some, let's say they say, look, you pay me an upfront of maybe like a minimum 1,000 or 2,000. We'll kickstart the work for you, and then if we win the case, we got recovery from the amount. Let's say it's 1 million. We get maybe a 10% cut or 20% cut. Now, technically, if you're talking about contingency is illegal, meaning there's zero upfront, you're just only getting the recovery basis, right?
and paying for the disbursements upfront as well.
Yes, so that is illegal. But there are firms that are very creative, right? There are people that are very creative. They would just say, look, you pay me 1,000 upfront, plus maybe 20% recovery, and then that is fair to both sides, right? Now, with that, I also have a view, which I've also experienced before, where there was this client came to me halfway in a SIPA context, right, adjudication, right? So this client said that, look, Jason, I already engaged previous lawyer. The previous lawyer have drafted payment claim, have filed the notice of adjudication, has even filed the adjudication claim, right? And then the opponent, which is a big law firm, they have filed in this adjudication response. So then now we have 5 working days to file in an adjudication reply towards the response. But the previous lawyer say, look, they are not in the capacity to do it because it's a lot of work and things like that. So they say, look, Jason, I need your help, right? So then I asked, okay, so the previous lawyer, how much they charge? So the client say, oh, they charge us a very minimum amount of fee, and on a recovery basis as well after that. Now, then my first thought at the point of time was that, typical. In my heart, of course, I never informed the client about this, but I told the client, I said, look, okay, we can do it for you, but we are not going to accept the recovery basis, because in my POV, of course, it's not illegal. It's just that it's unfair to the learned brothers and sisters, especially the SMEs, right? I believe there will be other construction solar practitioners like you that does everything from scratch. Or maybe he or she just takes in 1 file or 2 files per year, and it's enough to sustain him or herself. But that 1 or 2 files, if he or she experiences the undercutting by the learned brothers and sisters, he or she cannot sustain, right? Because everyone is going to, towards that direction per se, which is why in my POV it's not illegal. It's just, I would say it's not right. It's can I say unethical, or can I say immoral? I don't think that's the right word, but it's just something is off, right?
Yeah.
Like, how is it fair to those who are genuinely keeping up with the standard. So then I told my client, I said, look, I won't give you a recovery basis fee structure. I'll give you a fee structure package of filing everything, including all the way up to the enforcement proceedings, right? Because I always say to the client that say, look, winning a case doesn't get you the money. You have to execute it in the event the other side refuses to pay, right? So I will give you the package of this full package. I don't mind giving you stages or milestone payments and or installments, things like that, but I cannot accept the recovery basis,
Yep.
right? Because most of the lawyers in my POV, that's my personal view, they will take the upfront and then, yeah, they will do all the work from the get-go. But once you've taken the money, they might, in a way, not putting you as the priority anymore, right? Because they feel like, oh, look, I've squeezed the client out of the money. Now, in the long run, for me to get back my recovery basis, there's a lot of work to do. So maybe halfway they discharge me. Things like that. There are lawyers who do that. There are lawyers who just don't reply as well. I've seen as well, right? So these are the issues in my POV as a young lawyer running a firm. I have not hit, like what you say, the 10-year PQE, right? It's actually, in fact, I'm in my third year, right? So I would feel that how is it fair to us who genuinely, have a team, pay the salaries, to focus on the quality, to make sure the client's case is prioritized, and also being we are very responsive, attentive as compared to those running out their own firm, undercutting each other, take the money and chabut sometimes, right? So with that, I think it's very typical in the construction field. So coming to the medical field or the personal injury field, what is your thought on that?
Okay. As I said earlier, it's an open secret in the personal injury line that many lawyers resort to no win, no fee.
Right.
Yeah. And unfortunately, it trickles down not just from the motor vehicle cases. It has been penetrating the medical legal market, and I have no proof, but I have no doubts either that these things do happen. I have lost a lot of leads when I tell them the truth, what exactly is entailed. Now, it is already established as case law on this that what you can do is you can take a retainer. How much you want, it's up to you to decide. You can then charge the balance of your fee on a percentage.
Right.
Now, I'm not saying that I do this, but there is liberty for how you charge. You can charge in stages. You can charge in based on an upfront pre-agreed retainer plus the balance of contingency. Both are legal. But the reason why many patients veer towards the contingency fee arrangement is because many of them are not from means.
Right.
Medical legal litigation is expensive.
Right.
You don't just have to pay the lawyer. The most expensive expense is paying the expert's fee. Now, the expert's fee, it is actually something that the medical profession has actually endorsed, paying an expert. In fact, the Malaysian Medical Association has a guideline, a fee schedule of how much a doctor should charge if he were to give expert opinions in court. There is a fee schedule,
Right.
but they're not bound by it. They can charge less, they can charge more. Whatever it is, you must pay something. And who's going to be made to pay this? Obviously, it has to be the client.
Right.
It cannot be the lawyer, because can you imagine the lawyer having to fork out if let's say this case involves one expert,
Yeah.
5,000, 3 to 5,000 for their reports, and then another 3 to 5,000 per day to come to court to testify. That is easily sets the firm back by 10,000, if not more. For the catastrophic brain injury cases, you need at the minimum 2 experts, one on liability, one on rehab.
Wow.
So each, imagine, double the cost. And it's expensive. And when leads hear about this, I can tell even through a phone call how their voices change.
So they are dissuaded to pursue
Yes.
to pursue the action.
I've also known of some, after talking to me, they go up to somebody else, and next thing you know, I see their case in court. under a firm that is not, because our as I said earlier, the circle is small.
Yeah.
So we all know who are the players.
Right.
So if we don't recognize a name, and the defense lawyers know this as well, they also know who are the players. If they see a firm they don't recognize, you know what odds are it will tell you how exactly they managed to attract this client in the first place. So it's quite that is one of the difficulties we face getting the patients, converting the leads into clients, because of the upfront cost that they must be ready to pay. No brainer, right? If a lawyer comes out and tells you, never mind, I'll pay for everything, I'll pile everything, you just pay me back later from the winnings, assuming you can win lah.
Yeah.
No brainer. Who would these people go to? Of course, they will. Some part of me wants to, to tell them off, but part of me also says, you know what? If this helps you get justice, please go ahead, but I won't do it. You go and do it with this person.
Yeah. Because there's a dilemma. There's a dilemma on that also, right? Because if you're talking about in a patient's POV, he's very sick. Yeah. He's really injured and all these things. And then you still need him to fork out money first to get the experts to testify. Then only you have the second chance to go and fight for your rights, right? So you have to go through the first hurdle of getting expert report. Now, then my question would be, who are the experts? I suppose it will be the doctors, right? It will be the experts in this field to show that what is a causation to that injury, or the causations to the negligence duty, right? Yeah. So now, if that's the case, how often? Because in my POV is, no matter how many stories I've heard, how many experiences I've experienced personally with other law firms or other lawyers about all this contingency thing also, it's not easy for us to report, right? Correct, yes, we should, but it felt like there's a little bit of dilemma, right? Okay, maybe he or she, that lawyer, has some sort of difficulties that he or she needs the money or desperately, the case and things like that, or repo or whatever, right? That's why he did it that way. So who am I to judge? But on the other hand, I'm thinking, but if this thing is not put to a stop, then it's going to get worse, because there's going to be more creative ideas of circumventing the rules. So in my POV, if that is the case, then I wouldn't report my own learner brothers and sisters. In fact, I've not done it before. I don't think it's nice for me to do it, because unless I have concrete proof and things like that, I wouldn't do it. I wouldn't go to the extent of complaining to my about other lawyers here and there. But likewise for the doctors as well, right? Because I believe in, let's say I myself a patient today, I want to get an expert, a doctor, but the question is whether he or she is willing to testify for me.
Yep.
Right? That's the crux of the issue, right?
Yes, and it's the reason why our field is still very small, relatively small. It's growing, but it's still quite small because of challenges for getting access to experts.
Right.
It has always been difficult through the years. It's getting even more difficult now because in 2023, I think in 2022, it started in 2022, there was a surge in the reporting of successful medical negligence claims, which whenever you do that, it will attract attention. It's meant to attract attention. But whose attention did you attract?
Right.
Obviously, you attract these people who think that this is a lucrative area. Wow, it's medical negligence. Look at the amount of money that they won. Perhaps I can also get that. I want to share in that pie. And when the unfortunate effect of this is when all these lawyers, when all these people who have no experience dealing with these cases come on board, they try their hand. I call them. This is just my being naughty lah. I call these people trying to be playing hero lah. They try to play hero, but they don't know what they're doing, and they end up bungling the case for the client and for the patient, and the poor patient has end up paying costs to the other side or losing even more money.
Yeah.
And another secondary effect is the doctors and lawyers are already at odds, and this is globally. It's not just Malaysia. Doctors and lawyers have always had somewhat of an uneasy, like, relationship, love-hate relationship with each other. The reason why is because each time a demand or a claim is threatened, all right, or even a lawsuit is filed, frivolous or meritorious, from what I hear, it doesn't matter. The insurers will still will still increase the premiums for the doctors for the next year. And this, of course, will reasonably make them angry.
Right.
There's also a stigma. Yeah. There was a recent federal court, not too long ago, a federal court case where a private hospital was held liable for breach of their non-delegable duty to their patient. The hospital was made joint to pay the the multi-million-dollar award to the patient, when the actual tortfeasor, the doctor, was held liable for negligence. But of course, this is an area of law which is for another day, yeah. So the hospital was essentially held jointly liable, somewhat jointly liable, so they had to fork out money to pay, and it was multi-million-dollar award. So I was told that after that, the two experts for the patient and the expert for the doctor, who actually found negligence against the defendant doctor, that her own expert found negligence against them. There was a secret meeting. Of course, it was secret, but word travels, and I have no reason to doubt that it did not happen. That it did happen. They had a grilling session. The two experts were grilled. And I thought to myself, but why would you grill them?
Yeah, they're just doing their job.
They're doing their job. They were calling a spade lah. When there was negligence, there's negligence lah. What do you mean? What do you mean? Why do you call them up and attack them for that? So that colors the world, colors our practice. How we have seen it firsthand, how difficult it is nowadays to even get experts. Even our contacts that we regularly go to, they are starting to get tired. They're not getting younger lah. So we have to groom another crop of experts. But that's getting difficult because there's a lot of things lah. One is the whole medico-legal thing, and the second is, of course, the increasing demands for healthcare needs lah. So these doctors cannot divert their resources to giving expert opinions when they themselves are so swamped with their own practices already. So there's nobody's at fault here, but there's too many factors at play lah. And it's the one thing that is constant is the difficulty to get access to experts will always become more difficult as days go by.
Right.
Until there's some great revival lah. I don't know lah.
Yeah. That's then my question would be, what is the reform? Like any reforms, any initiative by any lawyers or any activists or from the government side? Because I am looking at there's no reform.
No reforms.
Yeah. So that's pretty bad. In that perspective, because at least for construction, I think last time the main hurdle for construction is expensive, right? Construction litigation is expensive. Why? Because most of the construction contract have arbitration clause, right? Now, when there's arbitration clause inside your construction contract, you cannot go to court, right? It's quite clear-cut. Section 10 Arbitration Act, it says that way. You must go straight to arbitration and then arbitrate it. Now, what if your claim is only 10,000? What if your claim is only 1 million? Or what if your claim is less than 1 million? It's a 500,000. If we go for arbitration, if it's domestic arbitration, it'll be okay. Like maybe slightly cheaper. But you're talking about international, if you're going through like MNCs and things like that, right? You have to fork out money first. It's the same concept, right? You have to fork out money first. You have to pay the arbitrators' deposits, you have to pay the administrative fees, depending on which institution is handling your arbitration proceedings. You have to, let's say if ad hoc, proceedings, you have to still fork out some money to get this matter to be resolved, right? Without knowing whether you win a case. I think that's the first hurdle. As what I'm just trying to draw an analogy. Like for patients, you have to get the first expert report. That's the first hurdle, right? And it's very expensive. But fortunately, we have this new, not to say very new, but relatively, I would say a very distinct and a niche and a very specific dispute resolution platform, the SIPA Act, which was passed and introduced and passed by the Parliament. It was enforced. It came into force. If I'm not wrong, it's 2014, and ever since then, SIPA is more prevalent as compared to arbitration, because SIPA, if there's a construction work done, you can initiate a SIPA claim, and you can get a decision in like what, less than 4 months, 5 months max, depending on how many documents that you file, any extensions and here like that. Now, of course, after SIPA, you have to enforce and execute and all these things. That's a different story, right? But at least the construction line, we have a saving, a so-called remedy, right? That's another way of doing it. So, in my POV, I think there should be some reform. There should be some, maybe anyone in the medical field, like maybe you yourself, can maybe start this conversation, right?
This conversation has been going on for many years. A lot
Right.
of people have been calling for, there's been a constant push
I
for
see.
pre-action mediation or a pre-action protocol like in the United Kingdom, where it's compulsory, not compulsory per se, but you are encouraged to undergo pre-action mediation before embarking on court, failing which you will be penalized with heavy costs. For the party that refuses to mediate, there will be cost consequences.
Right.
That's one. But it doesn't solve the one problem, and that is
Yes.
who decides the quantum of damages.
Exactly. That's my question as well. Because mediation, I mean, pre-action mediation is a good idea, but is it really effective? That's my thought. It doesn't, right? Even in construction as well, because if people just want to bypass that clause, or people just want to treat it as if like, oh, it's just a procedural wise, let the time lapse, then it just commence the action anyway, right? So the question then is, if the pre-action mediation doesn't work, right? Shouldn't there be any reform on the expert report? Because like what you said, there's a lot of B40 that needs help, and they cannot fork out like what you say, maybe like report, it costs maybe 40,000, 60,000, right? Is there any way that the public can get help? And by the way, is the pro bono how do I put it?
Legal aid center, is it?
Sorry?
The legal aid
The
center.
legal aid center,
No,
correct.
they don't cover medical negligence.
Okay.
There's only a very few areas where they cover. Medical negligence is not part of it.
Right.
If
Then
you're
how honestly, I don't know how it's gonna.
Okay, for me, the first thing that Malaysia can do is enact a statute granting patients access to their medical records. In Australia, in the UK, there are specific legislations by which a patient has a statutory right of access to their medical records. Here in Malaysia, we have very differing. There's no uniformity. There is a High Court decision that says patients should not be put to the cost and expense of filing a pre-action discovery application for their medical records. Some private hospitals have taken the cue and said, you know what, sure, I'll give it to you, just pay me some photocopying charges, no problem. Some don't take the cue and just keep quiet and forcing the patient to file pre-action discovery. The public university and the government hospitals, if you ever get a case against them, you will have to file pre-action discovery. They will always tell you, no, we can only give it a medical report, we can't give you the medical records, despite confronting them again and again with the same High Court decision. And many decisions penalizing these hospitals for aggravated damages, they still persist. So there's no uniformity.
Right.
There's no political will to make a change. And in fact, if you hear what a lot of the insurance companies and a lot of these stakeholders are saying, it looks like they are trying to make it even more difficult for patients to mount medical legal claims instead of the other way around. So
Right.
that's one. You need to codify access to medical records, because without it, you can't even instruct an expert. Some lawyers don't even know what medical records are. So that's one. Second is improving access to experts would require some leniency when it comes to the costing lah. You can't expect somebody from a rural area to be able to afford paying 5,000 ringgit
Yeah.
5,000 ringgit to not even know whether this expert is going to support their case. If they don't support the case, then it's 5,000 ringgit down the drain.
Yeah.
So I don't know what can overcome this except for a change in perception.
Yeah.
That instead of charging such high amounts, maybe I can charge less. It's a sticky area, because why do we want to cheapen experts? But on the other hand, should we not give way to access to justice?
Correct. That's what I'm thinking, because I think getting the medical records is pretty much the first thing that any patient should have access to. So currently there's no legislative on that, right? Okay. So now, if that's the case, then the next question would be this. Just now you mentioned something about some lawyers might have funded some patients. So let's say, okay, right, you know what? Let's do contingency. I'll fund you the fees for the expert report. If you win the case, everything, then I get maybe 30% cut or 40% cut.
Some go as low as 20. Yeah?
Wow.
There are some who are going as low as 20. And I've heard outside of Selangor and KL, some have gone as low for motor vehicle. Some have gone as low as 15%.
Wow. 15% for recovery, and there's zero upfront.
Yeah.
But normally, what is the range of your claim in a medical field? For example, let's say the patient wins the case. How much is the compensation? What is the range that normally, based on the court precedents? And
for a case to nowadays in 2026, for a case to be worth litigating, it should be no less than 100,000. Of course, there are, other lesser claims that are of lesser value. Of course, they deserve justice. But in terms of the resources that you have to spend, maybe less than 100,000 is not that worth it. So nowadays also, to really make it worth it for the patient, and of course for the lawyer as well, since we are the ones having to do the work, a claim of 100,000 should be, should be somewhat of a benchmark, but it's just, I guess, my personal benchmark, But doesn't mean that others don't deserve to be to go to court. I've also been told that nowadays, because of the pushback, and also one of the difficulties why access to medical records and quantum of damages is a tricky area, and that's not something that Parliament can actually step in. It's because for private hospitals and the public university hospitals, there's just so many indemnity providers. Everyone has different styles, everyone has different requirements, so there's no uniform insurer. Not like us lawyers, we have P&O and Aon. But for the medical profession, there are so many different providers. And for doctors, it is compulsory. So private doctors, they have to get insurance. For hospitals and clinics, actually it's not. Many of the small clinics do not have insurance. And that is another added layer of complexity. The government, they have the Ministry of Finance, but they too have insurers, Actually, the Ministry of Finance also has their private insurers or reinsurers.
Right.
So there's a lot of layers, a lot of voices, a lot of people talking. So when there's too many people, too many cooks in one kitchen,
The stakeholders.
too many stakeholders, so stakeholders. No, too many
We
stakeholders.
use a better word, huh?
Yeah.
Just
So,
in case.
nothing. Things will move much slower, lah. Rather than just someone can, like a patient, can just pick up the phone. Hey, can you accept this amount? Sure. So that is the difficulty there. It's the same for government hospitals. They've got the AG chambers, got a bunch of layers to go through, and then they also have to go through the Ministry of Health and then the Ministry of Finance. So it's a lot of layers. So that's why even now for government hospitals, that I've noticed this trend. Back then it was a bit easier to secure admissions or liability, just proceed to trial on quantum. Nowadays not so easy anymore. Nowadays they are fighting back. So if you get a government hospital case, you need to be ready for the long run. And how do this? So people who go to government hospitals, most of the time they cannot afford private lah. So if they cannot afford to pay 3,000 ringgit, 5,000 ringgit for private hospital treatment, what makes you think they can pay a lawyer and an expert?
Now, coming back to your practice then, since there's a lot of, all these insights, all these issues, right? I believe you act a lot for the patients. Of course, you're acting for some of the big companies as well, but mainly for the patients. How then do you overcome all these issues when you run your own practice?
For me, how to overcome them, I would start by saying by access to experts first lah.
Correct.
Okay.
Because it's gonna be very expensive, right? Because expert. So let's say a patient come and call you today and say, "Look, Evan, I need to sue someone." Okay. What's the next step?
Okay. Sometimes, well, I don't know if I have an answer for that because, as you know, when I said earlier, how some people just put down the phone, most of them just don't bother. They just don't appoint me at the end of the day. For those that cannot afford that, there are some people who really cannot afford, but there is a meritorious case. What I can do is, these are only applicable for the experts that I have long-term relationship with. So I've already built rapport with them. Sometimes they may be kind enough to do it on a pro bono basis. Sometimes they may be kind enough to take their fees in installments or ask for a lower fee. But this is very rare because how many of them, because all these things is extracurricular. They're already running their busy practice. Some of them are even lecturers. They got juggling two jobs. They got no time for their families, and they have to write a report for your case. They have to look through the medical records, look through literature, and write their reports. So some experts are willing to do that, but very few of them are willing to.
So then how do you then help with those patients? Let's say you engage your long-term relationship experts or doctors, so they will charge a very minimum fee for the report, and then clients will then advance the case lah.
Yes.
Right. Now, what if your long-term relationship experts, they are not able to do it?
Then you have to be very upfront with the client. You just tell them, look, I'm sorry that if you cannot afford an expert, I'm sorry, then it's best you just don't start in the first place.
Right.
Because you may be able to find, because this is something that I'm very proud of, and I feel a sense of pride and also a sense of wanting to protect this bubble that we have. Our small circle do not we do not conform to the whole no win no fee. We do not conform either to having funding litigation for our clients. So when we tell them, look, I'm sorry, we cannot fund the litigation for you because it's not fair to put us out of pocket as well for you.
Right.
You are creative. People are more creative than we think that we give them credit for. They can find money. They can. They just got to put their heart into it. I give you an example. In one case, this one, it was shown in the judgment. Okay. They went to a medical advisor first.
Right.
Somebody who he's not an expert. He's just there to screen the records first. They paid him a fee. They paid him something first.
Hmm.
I'm not going to say which one because I know who are the lawyers, and
Yeah.
it's best not to mess with this kind of things. But the fee was substantial. No way could somebody of that, no offense to the patient, but let's if you do a very honest take of this patient, how is he going to cough up that kind of money to pay in the first place? How? No way. Somebody must have paid for him.
Yeah. Somebody must have funded.
It could be his family.
Yeah.
It could be a third-party funder, because I know that there are some people who take loans for litigation. They just won't tell you who.
Mad.
Third-party funding is a thorny issue. It's somewhat recognized in Malaysia because of that recent case. I can't remember the name. It was recognized. They said, yeah, this was a legit contractual arrangement. I think the client's success was not successful or was successful. The third-party funder was successful in suing for his fee, his cut. So third-party funding is starting to gain a bit of traction. It's just that the mechanics of it has still not been ironed out. Nobody has got the time to deal with it.
Yeah. Yeah.
So maybe that's an option. I know that there are some patients who take loans from their family, friends to fund litigation. Nothing inherently wrong with that, but you got to pay back.
People are desperate. Sometimes, yeah, understand. Okay, so then your practice, currently you are in your third year of running your own firm. Maybe we go a little bit more towards not in a legal perspective anymore. We go out of it. How do you feel when you have so many things to juggle, right? You have to face, let's say, you have to deal with your family, parents, your friends, your relatives, your clients, the court, the opponent, and you yourself, right? Now, for me, myself, personally, I think it's not easy. But before I jump into that conclusion, I want to hear from your side. As an SME owner, as a sole prop of a law firm, what do you feel, and how do you manage all these expectations from everyone? You're solving everyone's problems. Sometimes you don't even have your time for yourself. So how do you go through it?
Who says I am? I will not sugarcoat this.
Right.
Yeah? This is 2026. We can talk about this openly.
Yeah.
Burnout is real. Mental health is real.
100%.
That's why the Bar Council has this initiative where you
Yeah.
can get free counseling.
Yeah.
And I swallowed that up. But it takes more than just 5 free sessions to properly get through this. How do I cope is, thankfully, I have a very supportive spouse. Yeah.
That's good.
Very supportive spouse. And the flexibility of being able to work from home. But it's not for everybody. I will be very honest. I'm starting to feel like I can't work from home anymore. I need an office space. But I can't scale because of the nature of our work and the nature of the turnover of our fees. It does not permit me to just up and invest money as how others can. So the financial bandwidth for me is different because I have other commitments. So I cannot simply just hire a few associates, rent an office. Every expenditure must be calculated carefully, because we do not have the stable income, like say, or the fast turnover, like say conveyancing or corporate advisory work, where the turnover is relatively faster. And even for construction, I'm aware that you all band together and push back against any of this contingency fee arrangements and insist that stage by stage payments to ensure cash flow.
Correct.
Which is something that the personal injury line, unfortunately, is not going to be able to achieve unless there is enough pushback from the legal fraternity against it. Because right now, the market is pretty much already established in the market. I had once told a lead that, I would charge a consultation fee because
Yeah.
I know this person, there's no case, but he just wants advice. But if I give free advice, I'll be doing a disservice to my fellow learned friends.
Friends. Yeah.
So this person calls me up thinking I'm like a cafe, I can just, do you sell matcha here? It's the same thing. They ask me, what is the limitation period? Do I have a case? I'm like, hello, my name is Evan. What's your name? Who is the defendants? So I tried this. I said, okay, if you want me to look at your case, I will charge a consultation fee. That fella just said, thank you very much, bye, put down the phone.
Standard, very typical.
Not once, twice. Twice.
It's the same person, no?
Not same person, different. One was a patient, one was a disgruntled son of a patient who wanted me to review their medical bill.
Right.
I said, this does fine, okay, you want me to do that for you, I'll charge a consultation because you can't just benefit from my services and not remunerate me. Why should I be deprived of any remuneration? Thank you. Just ghosted me. He just kept quiet. So the market has already established itself. And there are so many lawyers who actually defend this. Free market, bro. Favorite phrase, free market. I don't think so. I think in order to not put us out, because I don't know if we have the time to talk about this, but I can safely say that the no-win, no-fee arrangement is not exactly the best business model either. The reason being because if the lawyer does not take any money up front and they actually spend money, there's cash outflow, with no guarantee you actually recoup it in the first place. That's a bad business model.
Correct.
Imagine you fight a medical legal case for 4 years and then you recover maybe 300,000 ringgit or 200,000. Assuming they take 30% as their fee.
Right.
Yeah, it can be in stages or it can be on a contingency. 30,000, maybe you divide it by 4 years. How much will you really end up with? I did the maths once. It would not even, the monthly earnings from that case after 4 years will not even cover half a pupil's salary. It won't. Don't even talk about rental utilities. Don't even talk about paying your associate salary for over 4 years with no increment, no EPF, SOXO. You will not even scratch 1/3 of their salary. So that is how unprofitable it can be. So a lot of people, when they realize this, it perversely, I can say, look, the no-win, no-fee thing can also be a factor that drives people away from doing medical negligence work. Because in medical negligence, you have to cross the first hurdle, which is liability, which is not always apparent. And there is many ways the defense can fight it. You are dependent on an expert, which you have to pay for. So if these firms do no-win, no-fee, they have to pay the expert. They have to pay the expert to come to trial. So, and if they lose the case, who's going to pay the defendant's costs?
Correct.
You think the client's going to pay?
Correct.
No. So,
Correct.
it may not be the best business model, and this may drive a lot of people away. And that's why it has not grown as fast as I thought it would, but it is still growing. It is easier if, say, they do it in the motor vehicle accident where liability is not that difficult to establish. If the police has already found liability for you, how far can you run?
Right.
So a lot of times in motor vehicle accidents, liability will be admitted or they will just settle it. Or they will concentrate on quantum or damages. So it's just the math. So most of the time, money is somewhat in the bag for them.
Right.
And road traffic accidents don't take that long to complete as compared to medical negligence. So business-wise, the no-win, no-fee may be the one factor that's keeping lawyers from actually doing medical legal work.
Right. And it's also a factor that affects it compromises the quality of the work.
Yes.
Right? Because the no-win, no-fee so-called scheme, right? The lawyers might just abandon you halfway. Or the lawyers might just think that, look, let's say a few months down the road, we can see the reports, we can see the angle, things here and there. We know that, you know what, chances of succeeding is not high. So then they will just push it aside and then focus on other clients that they think that, you know, there's high chances on that. So those that suffer ultimately is the clients, is the patients, right?
Some of them are forced to do bulk work. So they'll take on as many as they can to make sure it's worth it.
Then they'll slave the employees.
They'll slave the employees or they themselves will die.
Yeah.
It's very easy to slip up if you do bulk work. You have to be very careful about that. And that too, if you do bulk work on just pure no win, no fee, you may have all the files, but money won't come in.
Correct.
So they are forced to do all these things. And like you said, the client will suffer.
Correct.
How many hands do you have? You only have 2.
Yeah. That's why I think for this podcast, I think the whole point for me to initiate it is to not only understand the your struggle of you running your firm, and also to create an awareness to the public, right? Basically to say, look, for us lawyers who run our own firms, right, who are small startups, right, we may not have the most resources, but we will still keep at the back of our head the ethical and the what we call that, the transparent conversation with the client from the get-go, what is the expectation, things like that, right? Now, I'm not saying that there are firms that, you know, don't do this. I would say, at least for me, fortunately, in this industry, construction industry, there's a lot of law firms, they are quite, you know, ethical. They keep up to the standard. Of course, they are like those, you know, we call it chapalang law firms, you know, they will just undercut here, and I understand that, but most of us, we are quite united in a way. Like there's a market rate that we can resort to, right? Because you're talking about industries, you're talking about companies. We don't act for individuals, we act for the companies mostly, right? Now, so coming back to, we have understood why you want to start your own firm. We have understood the struggle. We have also understood the practical insights of the medical industry. Now, if let's say today, a law student or a law graduate comes and tell you that, look, Evan, I watch Suits. It's very fancy. I want to be like Jessica in that movie, in the drama. I want to be like Harvey Specter in a drama, right? Now, what would your advice to these law graduates who want to be like a partner of a firm, or let's say they want to run their own firm? What is your thought on that? Maybe let's scrap the partner side lah. Let's just talk about running their own firm. What is your thought on that? What is the advice that you can give to them?
Okay, well, you cannot sacrifice vocational knowledge. You need to know how to be a lawyer first before you learn how to be a businessman. This has been hotly contested for many years now. Is law a profession, or is it a business, or is it a business first, or a profession second, or a profession first, business second? So many different views on this. I hold to the view that law is a profession first, but a business second. Yes, invariably there is a business element, because if you do not have the business element, the firm just doesn't survive.
Correct.
So the first thing you need to do is you need to learn how to be a lawyer, because there is such thing as opening up too early. You may escape it, but your clients may not. I have seen young lawyers who's in their first year of practice do brilliant at trial. I've seen 14-year practitioners who struggle to even string a sentence in court. And so the first thing I think someone needs to do is they need to learn how to be a lawyer first. They need to learn the ropes. They need to catch the vision, and they need to find an honest mentor. Somebody who is not going to, somebody who would not sugarcoat things, who would tell you the truth of what legal practice is. And it is not a cushy office job. It is not. The very fact, if you're a lawyer, you show up for your client. Doesn't matter, conveyancing, corporate, you are showing up for your client. And showing up means you cannot have the conventional 9 to 5. After 5, I can switch off. It's impossible. Unless you have clients that pay you very well. But the reality of today's economy, no. We put in more hours, but the value of the money we earn can buy so little.
It doesn't tally.
It doesn't tally. So my advice to these people is, even Jessica Pearson and Harvey Specter had repeated in the show that they worked long hours, that they slogged to get to where they are. But of course, they don't tell you what. They also went through, in the show also, they show they went through troubles. They went through a lot of ups and downs. And they went through a bunch of politics that does happen in real life. So if a young law student comes out and tells me they want to be a partner, I'm actually very happy to hear that, because they're very far. These kind of people are getting few and far in between. A lot of them don't even know what they want to do. Oh, I'm here for law because I'm here being a lawyer because I study law, I did the bar, okay lah, I might as well do. You hear that very often. A lot of them will say, I don't know what I want to do. I just want to explore. So, yeah.
Okay, right. Then I think one last question from my end, unless you have some for me, which I hope not. Now, if what is your thought or anything that you want to share to the SMEs, to the SME owners, especially law firms like you yourself? What are the things you want to share to them who may be watching this podcast, that they are struggling to meet their ends, to meet their commitments every month? How are you going to help them, or what are things that you can say or you can share to give some sort of encouragement that they're not alone?
Okay, I'm still finding my footing. So all I can say is this is just based on my personal experience. One is a support system of people in the same industry or same line of work. You need to have that support system, because that's how we keep out all these undesirable practices. We maintain the support system amongst ourselves. We tell each other what are the ins and outs of the particular field. We share knowledge with each other instead of hoard it to ourselves. That's one. Number two is, this is a skill that many people, even including myself, are struggling to learn. And that is adjusting your lifestyle.
Right.
Adjusting downwards. If push comes to shove, you must be ready to adjust downwards. If it means moving to a smaller office, if it means playing the long game, that's the third one. And if it means selling your matrimonial home, selling your car. A lot of the older lawyers actually, they tell us that they did all this when they were younger.
Correct.
It's the same thing. You have to be ready to adjust downwards.
To sacrifice.
Yes. And lastly, if you have the means, you cannot allow your ego to stop you from asking for help. If it means asking for a loan from your parents, just do it. As long as you keep afloat. Because if I'm like you, employees depend on me. They have to be paid first before I get paid. All this has to be paid first. So tough decisions have to be made.
Yeah.
So the third thing that I would like to say is, you must also be prepared to play the long game. Because right now in this day and age, it's all about flashy, showing how successful I am in such a short amount of time. Maybe for certain industries, certain lines, yes, it's possible, but not for medico-legal.
Right.
Not for us. We have to be ready to play the long game. All my other competitors, we either played the long game or are playing the long game, or they have already established themselves, which means they've already played the long game before they came into this area of law.
Yeah.
So that's the one formula I see, long game. You have to be ready for that. And delayed gratification. So hold off on buying that nice car, hold off on buying the nice Rolex watch. you may or hold off on posting on Instagram. You know, I'm going on a nice holidays,
Yeah.
spending my money.
Yeah.
So
Yeah.
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 That's
Agree. Okay. All right. Evan, anything else to the audience? Anyone who is gonna watch this podcast or is watching this podcast?
Don't cancel me,
Okay, all right. So, Evan, once again, really grateful for you to join us today. And I think you being our first guest speaker for this very insightful session, we are also very happy that you are able to share your very honest opinions in the medical legal field. How do you feel? How do you struggle? And how do you overcome it? Right? And what are your thoughts and opinions to the SME owners that they're not alone? Okay. Now, if I can just add a few words, in my POV, if you want to start a firm, right? That's just my POV. That is really not about the age. Or if you're talking about the let's say there are senior lawyers that will say, look, like what you said just now, who made the rule to say 6 years, 7 years, then you'll be more expensive and it's very hard to pay you, things like that. So if you have the experience and the skills, right, then I think you should start if that's what you want. Because for us, we have picked up this this route, and we cannot take a U-turn back. Of course, we can, anytime we can go back and here and there, but it's not easy, given that it's not. It's very hard for the other firms to tally with what we expected, the pay and things like that. But if let's say that day ever arrives for me myself, I think like what you said, the same thing. Put down the ego. Ultimately, it's just a job to meet your financial ends, right? But how I see the way that we should run to those who are watching or who will be watching this podcast, those SME owners or those who want to run a firm or those who want to run a business, do not think too much or too long. Think correct, take calculated risks and all these things, but it's really about execution. That you have to execute, you have to walk the talk. Yeah, you can't just basically tell me, look, I have these ideas here and here and there. Now, I came across this video of this entrepreneur that he said that ideas are useless. That ideas are useless and it's not going to make you profit. Because whatever you're thinking now, whatever ideas you have, someone in other world or other country, they would have the same idea already. Which is why sometimes you think about phone holder, right? Back then, no one ever thought about phone holder. No one ever thought about a lot of electronic gadgets or things like that, right? Until someone executed it. Someone did it, trial and error. So my POV is running a business is about trial and error. But doesn't mean that, you invest like 50,000 and then not knowing the ROI in return. Okay, of course, I also agree with you, Evan, that law firm is legal profession is, in a way, running a law firm is not the business first, it's the profession first. So profession, in my POV, it doesn't matter whether you start late or not. What matters is whether you have sufficient experiences, that you know the perimeter of the law, you are very well versed with the fundamental things, doing your own trial, doing your own hearings, things like that before your submissions from A to Z, then maybe you're talking about business after that. So that's how I see it. Okay. Now, once again, Evan, really grateful for you to be with us today. And to those who watch, who are watching or who will be watching this podcast, if you have any questions or if you have any issues, you can just drop us a message. I will say maybe our LinkedIn. I think Evan has his own LinkedIn profile and me myself as well. Then at least any questions or any SME owners who are watching this podcast, we can keep in touch, because what we're doing now is to help the community to build the small community to build a so-called like a long-term relationship with all the SME owners, so that all of us won't feel alone, right? Won't feel lonely. We are all in this together. We will help each other out. Whether you are in the legal industry or whether you are not in the legal industry, it's still the same, right? Running business, there's risk. Okay. Now, if there's nothing much, then we will just end here, Evan. Okay. Thank you, Evan. Really